I'm Joshua Wurtzel, and I'm a partner at Schlam Stone Dolan. So today I'm going to be talking about arbitration and how it often is not as fast and inexpensive as people make it out to be. In contracts, lawyers, business people often put arbitration clauses in their agreements. The idea being if there's a dispute that arises out of the contract, you have to bring that dispute by way of arbitration rather than litigation in court. A lot of people and a lot of lawyers think that this is better because arbitration is more streamlined, it's faster, it's going to be less expensive because it doesn't take as long, there might not be as much discovery. The issue is that that's not always true. The set of incentives that exist when parties and arbitrators are engaged in arbitration are different than in a litigation in court. And as a result, a lot of times an arbitration can actually end up being more expensive and in many instances can take longer than if you had litigated in court. A judge doesn't get paid by the case or by the hour, but the arbitrator is generally getting paid by the hour. So the arbitrator has an incentive for the arbitration to take longer, for there to be more hours and more things that have to be done in the arbitration. We find that a lot of times an arbitrator might be more inclined to allow certain types of evidence in, or to allow parties to present certain theories that had that same arbitrator been a judge in a courtroom, that same arbitrator might not have done, right? If you're a judge in a courtroom, you're going to be looking to resolve cases as quickly as possible. Litigation can and often does take years. Arbitration can be done faster, but oftentimes the arbitration will actually end up taking longer. So if, for example, maybe your lawsuit would take 3 years and the arbitration itself can be done in 18 months or in even 12 months. So you have a shorter time frame, but because the arbitration is actually potentially requiring more things to be done within that shorter time frame, it ends up actually being more expensive. If you have an arbitration that requires a panel of arbitrators, like 3 arbitrators, that's certainly going to increase the cost. But even when you just have a single arbitrator, now you have a situation in which every single time there's a motion, every time there's a hearing or any correspondence, you have to also pay the arbitrator in addition to the attorneys. Most arbitral authorities also have their own fees, so JAMS, AAA, depending the types of claims that you're bringing, depending on how much is at issue, depending on what you're doing in the arbitration, you have to pay fees to those bodies as well. So if you're in court, you pay certain nominal filing fees and so on, but for the most part, access to the court system is free for the parties. But access to an arbitration is not. And depending on the amount at issue, a lot of times the fees for an arbitration can start to really increase and can make the arbitration itself no longer cost effective.